Hi, everybody. This is Monty McIntyre, and I'm the host of Trial Alchemy. Today, we're going to talk with two outstanding ABOTA plaintiff trial lawyers, Dulin Kelly and Clint Kelly. Before we do that, let me just tell you a little bit about Trial Alchemy. This is a podcast that I produce once a month, and I only talk with outstanding plaintiff and defense trial lawyers who are members of the American Board of Trial Advocates, and we talk about what it takes to try a civil jury trial case these days, what works, what doesn't work. And these lawyers in ABOTA are some of the most talented and experienced civil lawyers throughout the country in the US. And it's a great honor to have them with us. So I'm delighted to have both Dulin Kelly and Clint Kelly with me today. Let me tell you a little bit about Dulin first. First, I want to let you know that Dulin was the national president of the ABOTA organization in the year 2017, and he worked in the organization for a number of years and still is heavily involved. Now, Dulin has been admitted to practice in the state of Tennessee since 1971, and over the course of his career, he started off in the DA's office, but over the course of his career, he's tried many, many civil cases. He's tried more than 100 jury trials, including many, many medical negligence cases. And in fact, Dulin and Clint are well recognized in their region, Tennessee and other nearby areas, as experts in medical malpractice plaintiffs for the plaintiffs. So Dulin is a member of the American Board of Trial Advocates. Membership in that organization is by invitation only, and it's made up of both plaintiff and defense lawyers. And back in the days when Dulin and Clint and I were admitted, you had to have at least 20 jury trials to verdict to even be considered for admission. And it's a great honor to be admitted because you have to be considered a great trial lawyer and also have to be somebody who is professional, courteous, and honest. And that's something that we all should strive for. Dulin is also a member of the fellow of the international. He's a fellow of the International Academy of Trial Lawyers, and that is also invitation only. And it's very strictly limited to 500 active trial lawyers from the U.S. and then 100 fellows from other countries around the world. He's a member of many organizations, but I won't list them all. And he's been selected as one of the best lawyers in America for many, many years. And he's also been selected as one of the super lawyers for many, many years. And so I could take a long time to talk about Dulin's extensive accomplishments, but I'm going to stop there and then I'm going to move over to Clint Kelly. Now, Clint has been practicing law in Tennessee since October of 1993, and Clint works with his dad, Dulin Kelly, in the Kelly law firm, and they are both outstanding and very experienced ABOTA medical malpractice plaintiff trial lawyers. So Clint has been heavily involved. He also is heavily involved with the American Board of Trial Advocates, and he's also a member of the International Society of Barristers and other organizations as well. And he's written books on medical malpractice, and he also has a blog, and this is on medical malpractice as well. And he is also very capable. Now, I've had some firsts in this podcast. Yesterday, I released the first podcast I've had where we didn't talk about trying jury cases. It was a discussion with the 2025 National ABOTA President about the rule of law. And today I'm recording a new first, which is a father and son practicing law together who are both ABOTA members and accomplished plaintiffs trial lawyers. So Dulin and Clint, thanks for being guests today. It's great to have you with me.
Thank you, Monty. Welcome.
So when we talk about trying cases, let's start with this. You've had a lot of experience, a lot of jury trials. And Dulin, you can share one if you want to, and Clint, you can share another one. But why don't you tell us about one of your most satisfying trial victories that you've had?
Well, it was probably our first malpractice case back in 1994,
Hmm.
where we had a lady who went diagnosed with a epidural abscess in her spine, and all the doctors missed the diagnosis. She was paralyzed from the waist down.
Wow.
And back then, of course, we got a nice verdict, but I still think that as much as anything, our client was one that the jury really emphasized with and liked, because that's probably the first thing we do. If we don't like the client, we think the jury's not going to like the client. She made an excellent witness, and we got a really nice verdict. And that's where we started back in 1994.
Well, that principle still holds true today, doesn't it?
It does. It very
Yeah.
much does. Because we've had a couple where we made a mistake. We didn't particularly like the client either, and neither did the jury. So we didn't end up with a very good verdict.
Now, I don't know about you, Dulin and Clint, but I remember when I was a younger trial lawyer, and sometimes you get a little bit overconfident when you have some success. And I made the mistake with some earlier clients of thinking, well, I don't like them all that much, but I think I can clean them up in front of the jury. That never seems to work. Has that been your experience?
Absolutely. Absolutely.
Clint, do you have any other satisfying trial victory you want to share? Is that good enough for you?
No, I actually think the best case we had was the case we tried in '99, which was against Vanderbilt. It was our very first trial against Vanderbilt, and we changed law in that case. It was a man who was driving a vehicle, a truck, and got intoxicated and hit a tree and smashed up his face, and was transported to Vanderbilt to have orbital surgery, where he cracked under his eye. And he sent him to a CT scanner because he had to be immobilized so that they could image his face. And they gave him a drug, a paralytic, to knock him out and keep him immobile during the period that they scanned his face. And when they sent the oxygen tank, because you have to breathe for him during the period he's paralyzed, the oxygen tank was only half full. Of course, no one
Oh,
knew that
no.
at the time. And you're supposed to monitor the patient to ensure that if the patient's running out of air, you can intervene in a moment's notice. Well, that didn't happen. This poor man went without oxygen for a prolonged period of time. And because of that, he was profoundly brain damaged by the time they had discovered he turned blue and revived him. And in the course of that trial, we won the case, but the jury assigned 30% fault against him, because the law back then was that if the patient provided the occasion for the medical negligence, the patient could be accused of fault, and that would reduce the recovery by the percentage of fault assigned to the patient. We didn't think that was right under the circumstances, because we thought that was an unfair law, and the trial judge agreed with us. And the case went all the way up to the Tennessee Supreme Court. Supreme Court, we prevailed there, and the court changed the law and said that when a patient, through his or her own negligence, simply provides the occasion to wind up in the hospital, a hospital is not going to be able to blame the patient for being there. That was very satisfying to us. It was a long journey, but it doesn't really get much better when you get a good verdict and get affirmed by the Tennessee Supreme Court.
Boy, that's a great result, and good job, you guys, to take it all the way up to the top court in Tennessee and change that law. That's great. That's going to help a lot of people over the years. You guys both are involved in ABOTA and have been for a number of years. And I just want to ask you, why is ABOTA important to you?
I'll go
And let you
first.
go first. Yeah.
Uh, I've been a member for more than 30 years, and I guess if I had to put my finger on one thing, Monty, it would be the relationships and friendships that I've developed over the past 30 years with people all over the country, both plaintiff and defense. I've learned a lot from them. We have programs all the time, and sometime in all of the things that I learned from other trial lawyers across the country. And of course, our purpose is to preserve the jury trial, which we've been successful at doing. But probably those friendships and the quality of lawyers that we're associated with means the most to me.
Clint?
I would drill down a little further and say it's within the midst of the relationships, it's having those relationships with defense lawyers. Because typically, in the role that we assume, you would fraternize with plaintiff lawyers, you would go to the American Association of Justice or your local trial lawyer association, which of course is nothing but plaintiff lawyers. But in ABOTA, because it's roughly 50-50, we get to spend time with defense lawyers, and it really helps us broaden our minds in terms of not only what it looks like on the other side of the fence, but to find out that we in some ways have more in common with some of those lawyers than we do our fellow plaintiffs lawyers. But it's great to be able to bring in an entire side of the bar that ordinarily you wouldn't have much contact with except in litigation.
Yeah, I think that's very, very helpful. Well, when you guys are getting prepared for trial, and I know good trial lawyers are usually preparing from the very beginning, but you also have this kind of time period, whether it's 1, 2, or 3 months before the actual trial starts, where you know you got to go to trial in this case, you're getting ready to go, and you're doing all that hard work to be prepared when the judge says, let's bring in the jury. So, what is your process that you guys have developed over the years to do that final preparation to know you're ready when it's time to go?
You want to go first, son?
Yeah, I think when you are on what I consider what you're saying is when you're on the eve of trial, the most important thing is to make sure everything works, to make sure that all of your electronics are properly formatted, to make sure that everything is imported and can be presented on the screen or on the TVs. Because as you know, Monty, nothing's more embarrassing and time consuming than to have an electronic failure in the middle of your proof. And you have to not only make sure that your systems work correctly, but that you have backup systems and you have other people who can help you if there's a glitch, if you will. And it just gives you confidence as you work through the trial that you know, hey, I'm set. I can present what I need to present. If something goes wrong, I've got a backup method, and you're not sitting there in front of the judge and the jury quaking in your boots because you've held up everything. There's nothing quite as it's almost like having dead air on the radio. There's nothing as uncomfortable as that happening. So that's one of the things I make sure I get done on the eve of trial.
Dulin, anything you want to talk about?
Yeah, I would say that, of course, it's always you get your voir dire done, you get your opening statement done. I have the greatest trouble trying to complete a closing argument. I remember I've done it several times the night before, and it just not the way to do it. And so, if you
No.
can make yourself do your closing argument, then you're way ahead of the game, I think, because then you can sit there during trial and either add things or take things out. But I think that's so important to be able to get that done prior to trial.
Yeah, I think that is very important. So when you're getting ready for trial, good trial lawyers are constantly thinking about their case and how they're going to present it at trial. And it's very common for people to figure out or use a trial theme that may help the jury understand the case. Do you guys have some trial themes that you have found to be successful in your cases in front of your juries? And what are they?
That's the hardest thing for me to do.
Yeah, yeah. It is very difficult to try to find a common denominator, one or two words that you could use to really encapsulate the cases. What you want to argue is the doctor made a shortcut or putting profits over safety or something along those lines. But Dad's right. It's just hard to find something that you can whistle to, and that's what you need to be able to do.
Yeah. Okay. So it's very case specific, but you don't really have often something you can get down to a pithy little short sentence, right?
That's correct.
Correct.
Okay. Well, that's okay. You got to do what you got to do. So now when you go to trial, and you've tried, Dulin, you've tried over 100 cases, and Clint, you've tried tons of cases as well. So in your opinion, based upon your experience, what part of the jury trial is the most important part and why?
Well, I
Say
think
right now, jury selection. Jury selection. If you don't pick the right jury, I don't care what the proof is, Monty. I don't think you're going to win.
I certainly agree with that. Dulin, you agree with jury selection?
I do, because like I said, if you got a couple of ringers on there, you just wasting your breath the whole time.
Yeah. Well, let's talk about that because you guys try most of your cases, not all of them, I guess, but most of your cases in Tennessee. And the rule in Tennessee in your state court is you have to have a unanimous jury verdict, right?
Yes.
I mean, the difference in a state like California, where I practice law, is you need to have 12 jurors and you need to get 9 out of 12 to agree to get a verdict. So, in your case, if you just have one juror who goes against you, you're sunk. So, when you're trying to pick those jurors, and we'll go into voir dire now, then, if you're trying to pick those jurors, what are you doing in Tennessee to try to make sure you have everybody on the jury who's going to give you a fair shot and not kind of sink your case because they can't be fair?
Dad, do you remember Mike Lawson's story that he told us about that juror in Ohio, the nurse? Do you remember that?
I do.
Why don't you tell that story?
You tell it because you know it better than I do. Then I'll
I'd
tell
say-
I'll tell the other
Okay.
one about God because you remember what that was like.
Yes. Okay. A good friend of ours, a former ABOTA member, Mike Lawson, great trial lawyer, tried a case in Ohio for 10 days, came back sullen, as we all look and feel when you lose a case. He was in the midst of jury selection, Monty, and this nurse was on the jury, and he had what he thought was a real deep personal discussion with this juror, made him feel reassured. The nurse kept convincing him over and over again, look, I'll follow the law. I don't have any preconceived notions about standard of care. I'll be open-minded. I won't use my influence with other jurors. I just want to give a fair shake. And this juror just had the way Mike said, just comforting. I mean, like nurses, I guess, can be. So against his gut, okay, his mind is telling him, let's let the guy on. He's reasonable. His gut's telling him, get this guy off. Well, he went against his gut and left the guy on. And sure enough, he lost the case. One of the other jurors that he talked to after the case told him that nurse picked the defense side early, I might add, and then got to the work of convincing all the other 11 jurors to fight against Mike or Mike's client, was a real advocate for the defendant in that case.
Wow.
And it's almost like, you remember that movie 12th Juror, where Henry Fonda uses his influence to change minds. That was basically the way Mike presented it to us. And Mike said, preach to us, whatever you do, well, don't let a healthcare provider on if you're a plaintiff, but even more than that, don't ever go against your gut, because your gut is telling you something that it senses that your mind can be blind to. I'll never forget that as long as I practice.
And Dulin, you wanted to say something?
I do. We had this great ABOTA lawyer from Memphis give a seminar, and he said, I'm going to tell you a question you need to ask. He said, if you got a juror or the jury said, now, if the judge tells you this is the law, and you go home at night and pray, and God tells you that no matter what the law is, you got to follow your heart, what I tell you. And I'm thinking, oh, come on. So believe it or not, Clint's doing voir dire in Clarksville. And he asked that question. And so help me, some lady raised her hand on the back row and said, well, if God tells me that I should do this, no matter what the law is, I'm going to do what God tells me to. I was just floored. And obviously the court said, you're excused. So we don't always ask that question, but I'm just telling you, you'd be surprised what answer you might get.
Boy, I think that's a good question. Now, in Tennessee, when you're picking your juries, I presume you have an unlimited number of challenges for cause. Is that right?
Correct.
And you've only got a certain number of peremptories that you can use.
Correct.
How many of those do you get?
It depends
Generally,
on how many parties there are.
let's
But
say if you had two parties.
I think the limit would be 8, don't you, son?
Yeah, 4 per person with a maximum of 8, and then they'll give you
Yep.
an extra 2 for the alternates.
Okay. Now, when you're talking to the jury and you're asking them your voir dire questions, um, what is your strategy and what are you trying to do in your discussion with them to get information that may let you get a challenge for cause that could be successful?
Well, I can tell you one thing. We were trying a case in Nashville where a brother was suing his brother because they were in the car together. You know, he had to, because he was the passenger and suing the driver. And we had 1 or 2 or 3 jurors say they would not follow the law. If this was the law, they would not follow it. And before that voir dire was over, we had so many big excuses. We had a mistrial and had tried again, had to reconvene a jury at another term.
Wow.
So, you got to explain what the law to them is, because some of them say, I don't care if that's what it is, I'm not going to do it.
Well, now, I'm sure you have a similar experience in Tennessee. What I've experienced and other lawyers in California have experienced, you think you have a challenge for cause, and often the judge will try to rehabilitate them, where you've got them to say things where you think, oh, they're off. And then the judge will do the old, hey, will you listen to me? Will you follow my instructions? Will you follow the law no matter what you believe? What kinds of things have you tried to do over the years to preempt that attempt by the judge to rehabilitate so you can really seal the deal if you get a good challenge for cause?
Well, I think you have to have have to go up to have a sidebar with the judge. You have to have a heart to heart with the judge. And one of the questions we've been advised to ask in the situation is, even if the judge tells you need to follow the law, will you have some doubt applying the law? Because anytime, when a judge asks the question, of course you're going to, unless you're a live wire, you're going to answer what the judge wants to answer. So you have to have a heart to heart with the judge and say, Judge, just because they're telling you this does not mean that you're starting off at the same place. We have it typically the way it comes up with us. You'll have one juror that's giving the other side the advantage. You're not starting equal. You know it. Defense lawyer knows it. Judge probably knows it deep down too, but you don't want to lose a juror because he's afraid he's going to run out of them or extend the voir dire. And so he rehabilitates them, but you know that juror has already staked out a position in favor of the opposing party. And some judges will be open-minded to that. And if they really believe that, they'll probably let the juror go. Some judges are just adamant. If the juror answers favorably to follow the law, that juror is going to stay on and you've got to burn your peremptory for it.
Yeah.
It's frustrating.
Yeah. It can be very frustrating.
And Monty, here's the killer question the court always asks. Can you be fair? Well, what juror is going to sit up there and say, no, I can't be fair? I mean, occasionally they'll say, well, I don't think I don't really think I can start in the middle, but 9 out of 10 going to say, well, of course I can be fair. And that's a killer. That's a killer question.
It is. It is. It's a challenge, and I think it's definitely a challenge for a lot of people representing plaintiffs because you're trying to get people off who can't be fair, and the judges are often trying to rehabilitate them. Now, in terms of the juries that you've seen, now, Clint, you've been doing this Dulin, you've been doing this longer than I have, and Clint shorter than I have, but
I've been doing it longer than Moses has.
Yeah. Well, you're a great trailblazer there, Dulin. So, in terms of juries, we've seen a lot of different kinds of generations over the years. And in recent years, we're seeing some of these younger generations. Um, and I imagine you're starting to see even fewer of the baby boomer generations as they're getting older. Are you noticing any difference in juror attitudes with some of these younger generations you're starting to see in your juries? And what are they that you've noticed?
I'll let Clint speak to this, but I think my biggest fault is trying to stereotype a juror. I think you make a huge mistake when you do that because young people sometimes will be for you or against you, just like an older person will. And I can't say that. I think the younger generation, for example, is more attuned to sound bites. So you got to be aware, aware of that
Right.
because their attention span, I don't think, is as good as the older generations are. But Clint probably could speak to that better than I can.
No, I agree. Dad and I have learned the hard way. Stereotyping, it just doesn't work. It's not, particularly in the line of work that we do, whether it's racial, whether it's sexual, whether it's, it could be any type, age, whatever you want to, however you want to use a way to discriminate. I don't mean that in terms of discrimination legally, but discriminating in your mind, how you're discerning who is the best juror. Dad's right. You can have a young juror that will be with you 100%, or you can have a young juror that won't be with you at all. The one thing that I keep in mind, though, as I'm coming up with my trial plan, jurors now, well, it's young and old, but particularly young, they're visual learners.
Yeah.
You have to be able to show, in addition to hearing, in order to teach well, because if you're just talking to them, I mean, I hear and read these stories about Jerry Spence having 4 hour opening statements just talking to somebody. I can't imagine sitting there listening. I certainly can't imagine nowadays a millennial sitting and listening to someone preach to them for 4 hours and thinking you're advancing the ball. It just doesn't make any sense to me. So I think we have to be very tuned in to what they like in terms of entertainment, what they like in terms of like that sound bites, clips, that sort of thing, to keep them attentive, because if you don't, you lose them.
Now, when you guys are trying to get ready to pick your juries before the trial, do you use things like focus groups or do you use jury consultants, whether it's sometimes, regularly, never? And if you have used them, have you found them to be helpful?
Dan?
Go.
Well,
No.
I was thinking what your thoughts are. Actually, I think we've only used a jury consultant one time throughout the trial. We've hired them at the beginning, or I'll say beginning, before trial, but haven't used one to help us pick during trial but once. I think Dad and I both agreed the contribution was minimal as we saw it. One of our good friends that we trust, who's an outstanding trial lawyer, basically said, look, he thinks you're wasting your time on him because he thinks he can do just as well picking a jury as a jury consultant would. So I don't, I guess I have a jaded view of it. I'm not sure how well they help you, but maybe if we did it 2, 3, 4 more times and had some different results, we might have a different attitude. We just once seemed to be enough with the lack of contribution we got out of that consultant.
Well, that's
Now,
all right.
Mark,
I mean, yeah, go ahead, Doolin.
we don't ever go to trial like that I can hardly think of without a focus group. And we have done those in person. We're going to try a new thing, and Clint can tell you more about that than I can, which is an online focus group. I'm really interested in trying that to see what the difference is, but you have a whole lot more people looking at your case than you do when you do them in person. But we always do focus groups. And
And
boy,
how
I
have
tell you,
focus groups helped you guys?
well, for one thing, they're going to tell you whether they like your clown or not. They're going to tell you whether they like your case or not. we rarely try to get them to value a case because we just found that that's not very helpful. But they can enlighten you on a whole lot of things about witnesses that they like or don't like, uh, certain areas of liability. So, and Clint can add some more things that I've already forgotten.
Well, the online part of this that's fascinating, you can expand the number of people that are seeing your case. So instead of typical number, we might have 9, 10, 12, we can have 100 or 200 or 500, depending on how broad a net you want to use. And what those people do is they create word bubbles. You know what word bubbles are, Money?
Nope.
They'll ask you, give us a name or a word for such and such, and you'll see how many times a particular word is used for a given situation. And the bigger the bubble, the more the word is used. And of course, that probably helps you in developing, well, it's no doubt it does help you in developing a theme, but it tells you what the hot buttons are in the case so that you can build your proof around these words. And that's something you can't get from a small focus group or even from two focus groups with, even 18, 20 people. But you get 100, 200, 300 using a word bubble. That tells you a lot about how significant a particular term or phrase is in a case, whether it's for you or against you. At least you know if it's against you, what you need to defend against.
No, that's good. So if you're using, let's say, 100 to 300 or 400 people, are you trying to have them be in the same geographical area of where the trial will be, or is it a bigger dispersed geographic area?
It can be both. It depends on how big. I believe it has to be dependent on how many people you want, because obviously there's only so many people. And like Dad and I have got a case right now pending in a town that's no bigger than, what's Jefferson City, Dad? Is it
8,500.
8,500? Okay. How
Hmm.
many jurors are you going to get online to hear a case in a community that size? It's going to be hard.
Yeah.
But if you got a community the size of Nashville, which is getting close to 1 million, then you have a lot more options available to you to get people from a similar community, which I think does make a difference.
Now, the cost of getting this online focus group of 100 to 400 people, is that pretty reasonable compared to in person?
The quote we got on the case that we were going to use it on, and who knows, we may still. The quote we got was probably about $25,000, but it's graded on a series of tiers depending on how in depth you want to get, because obviously the time involved is going to determine how much money you're going to have to spend. But it sounded like about 25 grand if you want to get the full enchilada with all of the data, all of the themes, the potential questions. It's what I would consider a comprehensive review of your case.
Well, that's good. Now, if I understand what Dulin said, this online focus group you're going to be doing in the future, but you haven't done it yet.
That's correct.
Well, I tell you what, we'll finish this interview, but let me know how you feel about that after you do it. I'd like to hear about that. That'll be
Well,
great information. So I appreciate that. Now, in terms of picking your jury, in California in the last 10 years, there's been this development of what they call the mini opening. And what we used to do historically is the court would say you have to prepare this short little introduction. And the only way you could get all the attorneys to agree to it, it had to be so vanilla, I didn't think it was very helpful. And the difference of the mini opening is each lawyer is given about 4 minutes or so to give the jury a short introduction to what the case is going to be about. Do you guys have anything that's been developing in Tennessee like that? And if you have, how have you found that to be helpful for you, or what are your thoughts?
well,
No, go ahead. Yeah, I know what you're going to say. Say it, Dad.
well, it depends on the judge. Some judge is going to thinks he's going to tell the jury about the case, which you know how that goes.
Yeah.
However, some judge will give you the latitude And I always like to do that because you got to tell the jury what the case is about. I mean, they're just otherwise they just sitting up there answering questions, wondering, well, what's this all about?
Yep.
So we try to do that. And most of the times we're successful. Some judges, like I say, want to do it themselves.
Monty, there is a law that passed, it's now in our rules of procedure, which does give the attorney the right to explain or give a mini opening statement in advance of voir dire. So you are allowed to do that now by rule. I'm sure it's you have to be careful about it because it's in the discretion of the court as to how far you can go. But the thing I thought Dad was going to talk about with regard to the mini trial is during COVID, our Supreme Court was trying to convince the bar to go forward with jury trials with fewer jurors, and in some particular instance might even be able to do them remotely. But there had to be an agreement to reduce the juror number from 12 to 6, like it would be in federal court. We couldn't find any defense lawyer that would be willing to reduce the number of jurors from 12 to 6 because obviously they know that all it takes is one to ruin your day as a plaintiff, and they figure their odds are better with having plaintiff having to convince 12 instead of 6. So we couldn't get anybody wanted to bite on it from the defense side.
Well, I tell you what, you guys might find happens in Tennessee. The mini opening was started a number of years ago in California. Defense lawyers tended to hate it, but then it became something that was mandatory that the court had to allow, similar to what your law just did. And actually, these days in California, both sides love it because it gives them an opportunity to talk about the case in a brief way, tell the jury what's important, and a lot of the lawyers will also talk about the bad issues and get that out on the table right away because that's so important, as you guys know. So in terms of once you've gone through voir dire and you've picked that jury, now you're going to be giving your opening statement. What's your strategy for how you approach that, how you tell the story? For example, Clint, I imagine you're using visuals and you're using stuff to keep their attention. So what are you trying to do to tell the story in a way that they'll get it and they'll remember it?
I use PowerPoint. I mean, I can't imagine doing it anymore without it. And, I'll try to pick the main images that I think will encapsulate the case. I'll use, points, try not to overload them, I don't do a bullet point, like 6 bullet. I don't go down that road, but if there are elements, I'll try to give them the elements 1, and then I'll take away 2. So they're only focusing on one point. But I don't know how you could do an opening statement these days without using PowerPoint so that the jury hears you and sees you. The only thing I think you have to be careful about, whether it's an opening or closing, is not talking over your presentation where they can't do 2 things at once. So you have to make sure that you marry what you're saying and give them time to read if you need them to read something and then come back to it, or else you run the risk of just running over what you're presenting, and then you've lost the punch that you wanted to deliver.
Yeah. And in terms of the medical stuff, I imagine that one of the things you find helpful is you can probably have some images or things you can use if you do you ever demonstrate with pictures or videos some of the medical stuff they're going to need to learn or procedures they're going to hear about?
All the time. I mean, if you can't show it, you're not going to win. It seems to
Yeah.
me the whole point of being a good malpractice lawyer, plaintiff or defendant, is being able to take a complicated medical concept and turn it into something that a 5th grader can understand. If you can't do that, you're going to have trouble winning the case.
Yeah. Well, now one of the things that I think that juries tend to do, I'm guessing they do it in Tennessee. I know they do it in California. I've done a lot of plaintiffs' medical malpractice cases trials here. Is they tend to give the benefit of the doubt to the doctor, and they're kind of thinking the doctor is just doing their best trying to help the patient. So how do you, in giving your opening statement and presenting your case, how do you try to get the jury to understand that there's something else at stake here, and they have to be properly treating the patient within the standard of medical practice?
And then, Monty, you better clear that out in voir dire, because if you if you wait till your case is underway and you find out they think the doctor's just doing his best, then you're in trouble already. And when I give an opening statement, I start with the emphasis on the defendant. In other words, I say patient came in to see Dr. Smith. Dr. Smith had several diagnoses available to him, and I may go 10, 15 minutes before you name my client, so that the attention is immediately on the defendant and the defendant's conduct.
Okay.
But that voir dire question you just raised is something you gotta know before you start.
Right. And that's something a lot of people feel. Don't they think that in Tennessee pretty commonly too?
Yeah, pretty commonly, but over the years we've learned we much rather sue hospitals than doctors.
Yeah.
So a lot of times our case is against the hospital, but yes, you are correct that I think they do have some sympathy for doctors. But I'm going to tell you, I think since COVID, that attitude's changed somewhat. What do you think, son?
Yeah, I do. I also think that jurors they're more suspicious of what a doctor's opinion or an expert's opinion is because of that's the lingering effects of COVID. And I also think with regard to hospitals, I think they see hospitals now more of a business than they ever used to. And so they judge it like a business. And that helps the plaintiff lawyer convince them that mistakes can be made in an assembly line type of medicine.
Yeah, I think you guys are seeing similar things in your area that other people have seen in other parts of the country, where they feel that since COVID, jurors have been more critical of doctors, of hospitals, things like that. So I think that is something that probably helps you and people who are representing patients in trying to successfully present your case to the jury. How do you guys, when you're in the case, deal with bad facts? So you're probably talking about them in voir dire, but what do you do to deal with them when you've got some bad facts that you've got to deal with?
Like Dad said, you got to bring them out in voir dire. You've got to be very open with the jury about it. And it's you just have to. Some people you think you can work with on them. Others you say they got to go. And if they don't go for cause, they've got to go based on a peremptory challenge. But you have to deal with them head on, because it never fails. Whenever you try to skate over them, you'll get shot down every time.
Well, now, Dulin, when you started practicing and when I was starting to do this trial work, it was all written records, and now things are all generally electronic medical records. And in terms of the electronic medical age that we're in, and this is for both of you, Clint and Dulin, has the electronic age made it easier or harder to find when records have been altered? Because that can be significant in a medical case, right?
Well, we don't see too many altered records, but your answer is yes. I don't like electronic records because they are so templated that they just carry them forward, and they don't. There's so many things they can choose as an option rather than handwriting it out.
Yep.
Well, I love those handwritten records, but those are gone now, just about.
Yep. You got any thoughts on electronic records, Clint?
We have a way to determine whether electronic records have been, meddled with. In fact, right now we're in a case where we're getting the metadata, the audit trail, and I call it the metadata, but it's audit trail, where you can open up an Excel spreadsheet and you can find every place in the chart where an entry was made, who made the entry, why the entry was made. And so you can use that as a means to determine, was the chart changed on a subsequent date, and by whom was it changed, which is essential if you think that there's data that has been changed. We had a case a few years ago in Memphis where there was a change, a very significant change in the chart about a man who was wearing compression stockings, those sequential compression devices. And this nurse made a change in the chart about how that device was working. Now, there wasn't any dispute she made the change. The question is, when did she make the change? It turned out she made the change later than what we thought in the chart based on the recording, later than what it said. And that really, I think it spooked the hospital. I think that any judge told me when I was in law school clerking, and he's been proven right every time, if you can ever prove the chart's been changed or altered, first of all, you're probably not going to wind up trying that case. Second, if you do, you're probably going to win it, because if the jury ever thinks that, they're going to immediately assume that there's been fault.
Yeah,
I never
that's
had a
been
trial
my
where the chart was changed.
that's been my experience. I mean, if you get altered records and you find it, usually that case is going to settle.
Yeah.
Because
We've
that's
never had one go to
devastating to the
trial.
defense.
Yeah, yeah. And the one what Dad was talking about, the written records, one of my earlier cases was a case with an emergency department note that you could tell that used to be they had copies. They would have like a pink copy, the white original, and a yellow copy. And when
Yeah,
the pink copy and the white copy didn't marry up, you knew something was wrong. I mean, it was obvious, and that was an easy way to prove that there had been a change. But those days it's not that easy anymore. Now we have to go through this process of looking at audit trails to make determinations of when changes have been made.
yeah. Well, now when you're in the trial, you get a lot of different kinds of trial judges, and sometimes you may run up against a judge who's a difficult judge for you presenting your case. How do you guys deal with judges if they're being difficult during your trial?
Well, you know one, son, so go ahead and tell them.
I think it depends on where and when it happens. When you deal with a difficult judge during the trial, you can adapt. I think there's ways that you can deal with it, because I do think juries make decisions irrespective of what the judge says. I know Dad said that when the judge is telling the jury about the case, it may form an opinion, but I really believe juries come up with their decisions regardless of how the judge acts. We had a case in Knoxville with I would call him a curmudgeon of a judge, but he was an equal opportunity curmudgeon. He let the defense have it just like he let us have it. So, but the other judge I'm thinking of, Dad and I are thinking of, is a situation where a judge will stake out a position. Imagine you present your jury charge and you're sitting there, and it's rapid fire a lot of times in a charge conference. You're trying to put it together. You think you know what you're going to argue. And then at the last moment, the judge slides a piece of law in there, which he thinks is the law that the defendant wants, and it's just there. And he's not going to change his mind because he's made up his mind that that's the law and it must be charged. And in Tennessee, it's awfully hard to reverse a trial judge who gives a charge that he thinks is part of the law. The error has to be fairly gross to get him overturned. And when a judge does that, best you can do is try to adapt in the closing argument. But Monty, it can be a dagger in the back.
Yeah.
I don't know what you do in that situation other than you try to preserve the error, which thankfully in Tennessee it's automatic. I learned that not too long ago, that if there is an error in the charge, it's automatically preserved for appeal. But that's the one place where a judge who is disagreeable, or I'm just going to say it flat out, who tends to favor one side over another, that's where that judge can deliver a death blow.
Is it if you can show abuse of discretion in giving that jury instruction, is that sufficient, or do you have to show more?
in Tennessee, well, first of all, you'd have to show a whole series of abuses to be able to even get to that point. The thing that concerns me is a judge in malpractice in Tennessee, the law is written to protect the doctor. I can give multiple examples of that, particularly when it comes to standard of care and the presumption against an injury, if you will. But there are situations where a judge can give a principle from a case, and if it's close, if you got a tight case that could turn on a razor's edge, a charge, a particular charge that gives the jury license to find for the other side. Like I said, it's a death blow, and there's nothing you can do about it, because as long as you can prove it's in a case somewhere, a lot of times the Court of Appeals will sustain it, unless it's just doesn't belong in the case at all, which is hard to prove. I know I'm taking a circuitous route here, but I'm trying to think. I don't know how you deal with that other than just hope that you've proven your case where you can get over that bad charge.
Yeah. Okay. Well, now when we're doing into the trial and you're doing your examination of witnesses, I think probably most lawyers think about cross-exam, and I want to talk about that in a second, but direct exam is important too, isn't it? And, why do you guys think direct exam is important? And what do you do to make sure you properly prepare your clients for the direct and have a good direct exam in front of the jury?
Well, believe it or not, we've just discovered another service who will coach your witness. And by the way, Monty, we ain't even talking about depositions, which probably are more important or as important as the trial itself. But we have a lady who will coach your witness, and we have tried her out, and we're very pleased with her so far. I think the thing that hurts more than anything else in direct examination is you get a witness, be it expert or even your own client, who rambles on and on.
Yeah.
That's the worst. And we try our best to keep it simple, less is more, and keep that client from rambling and answer the question and then shut up. That's my take on direct examination. And of course, some of them are real good at telling a story, and then some of them just they'll answer the question, they won't do anything to just shut up real quick, and that's not very good either, because there's no personality. No personality is coming out under those circumstances.
Clint, any thought on direct?
Yeah, the ramblers will kill you every time. And we had a client get up there and started out strong. It was a long examination. And in his defense, he had to be on the witness stand a terribly long time. But that doesn't change the fact he just started blacking out towards the end. And in this case, the judge allowed the jurors to submit questions after his examination to allow him to answer these questions. And it was terrible. I mean, he went on and on and on, and you could see the jurors looking at him like going like this, because it's so counterproductive. And I don't know, Dad and I try so hard to train our clients to answer as succinctly as possible, except there are times when you explain, but to not have diarrhea of the mouth. And it just seems like no matter how hard we try, whatever that client's personality is, like an actor, whatever the actor's got in him, it's going to come out. And when it does, it's devastating. You wish you could just wrap it up, but if there's more to be gotten out of that client, you got to get it. You got to find a way to get through it. But they'll kill you every time, Monty, the ones that want to talk a lot and just ramble on.
Now, on cross-exam, the classic cross is what I would call the closed cross, where you're controlling the witness, you don't give them much room, and you're got a short string on them or rope on them. But there's also, the well-known example would be somebody like Jerry Spence in his day. He would do these cross-examinations that I would call open cross, where it's like he didn't even care what the answer was. He would just be telling his case and telling his story about the cross. Do you guys use one type only, or do you use both types, or do you use different types of crosses for different witnesses and situations?
You want to go
I'll
first,
tell
son?
you, yeah, I do not do the Jerry Spence method. I'm a get in and get out. And the last thing, we deal with expert witnesses, which are the most dangerous of all. And if you get up there and you start asking one question too many, it can be fatal.
Yep.
And so my view is you get up there, you establish what you need to establish, and you sit down and you shut up because there've been too many. And there, listen, you can go in there with the greatest intention to do just that and get drawn into a pitched battle in a phone booth with an expert that you're going to lose more often than not. You're going to lose that battle. And it
Yep.
can totally screw up your momentum. It can screw up your mindset because you go on an off ramp and you never can get back to the interstate. And so it takes an incredible amount of discipline to work your way through your, need to have it outlined, need to have every question laid out, and just go through it as best you can, but stick to the script and sit down. Because I think it makes a difference. I was watching that Karen Reed trial, and I watched one of these experts take that prosecutor and wear him out because he just couldn't stop. He kept going on side issues with her, and she owned him. And that's the worst feeling on cross-examination.
Well, now sometimes if you've got your cross-examination well prepared, you got to start strong and you got to end strong, right?
Yes.
But you also sometimes you may get something that's such a significant concession that you maybe haven't finished all your questions, but sometimes you just should shut up and sit down right then. You guys ever have that happen?
Yes. And then, Monty, sometimes you get these experts that just will not shut up, and you have to ask the court to intervene and
Yep.
say, Judge, will he just answer the question yes or no? Then explain all he wants to. Well, after 4 or 5 times of that, either the jury's tired of it
Yeah.
or the expert gets the message and, quits going on and on and on.
Yeah,
Yeah.
Dad's thing will be, you remember my question? I mean, that's how you deliver the point. Do you remember
Yep.
my question? Or you start out with the expert saying, I'm going to ask some very specific, direct questions that only demand a yes or a no or I don't know. And you get that agreement on the front end. And then when they start going on, which a lot of them inevitably do, you either, if you have to go to the judge, go to the judge, but on the front end, you just go, do you remember my question? And that points out to the jury how they've wandered. But get back to what you said about some point coming up in cross. I'm of the opinion now, if I leave something on the table, so be it. I don't want to get owned.
Yep. Now let me ask you about this. In Tennessee, do you guys have the right to call the defendant and cross-examine them at the beginning of your case?
Yes, sir.
Okay. And we've got that in California, and that can be a very effective tool. But also, what can happen is the plaintiff might make a great cross-examination of the defendant early on, but then if the defense lawyer decides they're going to just do their exam right there at the beginning of your case, you might not like that part of the story being told right then. How have you guys found the tool of cross-examining the defendant early on in your case?
We don't do it that way. We play a portion of his video.
Ah,
Because we can
Remember,
use the
Dad
parties.
said that's where depositions win the case more than direct. That's exactly the examples. Dad plays the video, and see, that's contained. All they
yep,
can do is play parts they want to play of it, but it's contained.
yep. So that's great. So you've avoided that issue by using the video testimony.
Yep.
And so you just called the defendant under cross, but by playing portions of their depo.
Correct.
Great. Okay. I love it. That's a great approach. So now when you're, let's say when you finish putting all your evidence on and you're giving your final argument, What's your strategy now? What are you trying to accomplish with the jury then? How are you going to give them the tools to not only decide negligence and causation, but you're also, how the heck do you help equip them to figure out how to put dollars on non-economic damages?
That per diem argument about the job offer, I think is the most effective way. I wish I had done it in another case. By the way, as a follow-up, you cannot shortchange your damages. You've got to, that's another place where discipline must be enforced. You've got to segregate a portion of your final, preferably half or 2/3 of it, for the damages, because I think that can make a difference in winning the liability. But putting all that aside, I like the job offer, where the want ad, where you lay out what happened to the plaintiff, and that's assuming the plaintiff is alive, and you go through the impairments and so this is what the job is. What would you compensate this person for that job? That think that's a particularly effective way to show damages for someone who's still alive, who has permanent impairment, has to go through for the rest of their life a serious injury.
Yeah. Dulin, any thoughts on this?
Yeah, we don't like taking clients to court that don't have a visible injury.
Yeah. That makes a lot of sense. Well, listen, you guys, this has been a great conversation. I really appreciate you sharing your wisdom, and people are going to learn a lot from listening to this interview. As we're closing this down, I want to ask you one last question, and each of you can give me an answer if you want to. And so if you were to give advice to somebody who wants to become a good trial lawyer in the civil jury trial arena, what advice do you have? Maybe it's some advice you were given when you were younger. Maybe it's things you've learned over the course of your career. But what advice would you have to people to say, this is how you can become a really good civil jury trial lawyer?
Well, I'll steal the show by saying there's nothing more important than being prepared, period. You can't over prepare. And that's the number one thing you must do.
Okay, that's great advice. I've said a lot, I may not be the smartest guy in the room or person in the room, but nobody's going to out prepare me.
Right.
What are your thoughts? What is your wisdom, Clint?
I go back to Tommy Malone's advice that I got when I was a cub lawyer, which was the most money he ever saved in his career was on the cases he did not take, meaning be very discriminating in the cases that you take.
Well, that's great advice too. Well, listen, guys, thanks for sharing your wisdom and your advice. Thank you for all that you do with ABOTA, and thank you for all the great work you're doing with your clients and getting them justice. Really, it's been great having some time with you, and thanks for coming on to Trial Alchemy.
Well, thanks for having us, Monty.
Thank you.